There was an individual who sent out a claim of right, and subsequent to that, they sent out a claim for a discharge off the Consolidated Revenue Fund. Now, this original claim of right that they sent out, it was built by calling on the Bible and on the doctrines and the beliefs that come from the Bible. Basically, in the claim, they were stating about common law rights and bringing forth the fact that God is above all, and it's the Bible that grants us, by God's right, our common law freedoms. And she wrote that they were claiming their rights and freedoms based upon this truth. Now, within the claim of recognition and the subsequent claim for a discharge, there was no international law or domestic law pointing to our fundamental rights and freedoms as men and women or human beings. The evidence that was used to support any claim that was made came from the Bible and biblical understanding. Now, let's see what the government said. We are writing in response to your correspondence, dated March 23rd, concerning notice of amendment. Given the nature of your request, we have been asked to respond to your letter and take appropriate action. Therefore, you should not expect any further response. After a review of the content of your correspondence, we wish to inform you that the objective of the Receiver General is to protect the integrity of the Consolidated Revenue Fund. This includes ensuring that all money owing to the federal government is deposited to the credit of the Receiver General, directing and controlling the movement of money out of the Consolidated Revenue Fund, maintaining the central accounts of Canada, and producing public accounts. Also, we must inform you that, pursuant to the Financial Administrative Act, all funds held in the CRF are managed by the Receiver General on behalf of the Government of Canada. As per Section 26 of the FAA, no payments shall be made out of the CRF without authority of Parliament. Therefore, you are not entitled on obtaining shares. We recommend that you consult with a lawyer of your own choosing in order to be informed of your legal rights regarding this matter. This individual received a letter back from the government office who is responsible for the Consolidated Revenue Fund after they had sent the claim to this office. They wrote back and they said, given the nature of the request of the documents that you sent, we have been asked to respond to you, and after this letter, you won't get any more responses from us. That's what they wrote back. Now, the nature of the request was to access the Consolidated Revenue Fund. If we look into the laws that govern the Consolidated Revenue Fund, anytime a request for an appropriation, a request for a requisition, or a request for an instruction for payment is sent to the government minister, it creates an obligation upon them. They have to now take the documentation, take the evidence that was sent with the documentation, and see if they can make a Consolidated Revenue Fund discharge. See if they can make a reconciliation between the nature of the request, the demand, and the rights that protect the Consolidated Revenue Fund. So there is a legal obligation that falls upon them when you send your documentations. They're going to examine your request, and they're going to examine the evidence that you sent with it to try and make reconciliation in order to do the discharge. So they wrote her back, and they said, given the nature of your request, we have to respond to you. We are responding to you, and now you won't receive any more responses from us after having read your documentation. Why? The Receiver General's office wrote back and said, after a review of the content of your documents, we're not going to respond again. So they're being pretty tough. They're saying, we read the contents of your documents, and based upon those contents of those documents, there's no obligation upon us to do anything on your behalf. Therefore, we're not going to respond again. And they went on and continued to tell this individual that the object of the Receiver General is to protect the integrity of the CRF. Now, in those documentations that were sent asking to make a discharge off the Consolidated Revenue Fund, the operations of law that were called on, we already spoke about. They came out of a biblical context. They also came out of internet myth. I'm going to show you. The letter, the response, goes on further to say that it's the Receiver General's responsibility and power concerning directing and controlling the movement of money out of the Consolidated Revenue Fund. So the Receiver General is in control of and is directing the movement of money that comes out of the fund. It's also his duty and responsibility to maintain, now watch this, the central accounts for Canada and producing public accounts. That's the job of the Receiver General. Those are the duties of the Receiver General. Now, did you catch that? They use one word, maintain. Maintain the central accounts for Canada, and then through these central accounts, produce the public accounts. Now, this central account that Canada has, or central accounts that Canada has, this is concerning our natural rights, fundamental freedoms, our ability to make instructions for payments, not the producing public accounts. But they went on to describe to this individual the differences that are in operation, and they described the duties that the Receiver General had. I'm gathering that whoever responded to them was trying to help them by bringing this forth. Article 36, reconciliation of claim with evidence and instruction for payment. Where a payment out of the Consolidated Revenue Fund is made in respect of a claim for settlement, the Receiver General shall examine the claim and make a reconciliation between the claim and the supporting evidence and the instruction for payment to which the claim relates. The document goes on to state that you are not entitled on, notice that, on obtaining shares. That's what they responded to her. They said that we reviewed your content, we're responding to you, we've explained to you the duties of the Receiver General, central accounts, public accounts. You are not entitled on obtaining shares based upon your claim, and we won't respond to you again. That was done in March. And remember, the government fulfilled its obligation. They did review the content of the claim for the discharge. They found the evidence wasn't supportive, and they didn't allow her to obtain her right. Now, the content was built not upon the principles of international law and domestic law, where we find our fundamental rights and freedoms, where we find the guarantee that we have for the right to enjoy a living, not to pursue after a living, wasn't built on that. It was built on biblical, among others. And that's the response they got. Now, of course, this lady was discouraged, and she responded to their letters, looking for why she can't have access. Because in the beginning, when she started all this, she didn't understand her fundamental rights and freedoms. She didn't have a proper claim of recognition in play, nor did she have an ability to make a constitutional challenge. She didn't understand any of these operations of law. She knew internet myth. She knew things that are floating out there on the internet, and based upon that, she was trying to claim them. Dear Madam, I am writing in response to your correspondence dated March 29th, 2012, concerning my notice of amendment. I take this opportunity to complete in my field and sending you my initial claim of right dated November 14th, 2012, and my demand of appropriation sent to Monsieur Raymond Bachand, Minister des Finances of Quebec. Supremacy of God. God alone is my authority. I'm child of God. I'm human being. I'm a woman. Act under God authority. Canada is an incorporation I don't serve the Queen. I'm an adult, not a child. I claim the right to access the Canadian Consolidated Revenue Fund to pay for my remittance slips. This said right is accorded to me through the document bearing the number found upon the valuable writing termed birth certificate. You will find all my claim in the documentation, and if there is a problem with the submitted paperwork, you can communicate with the undersigned via mail. Sincerely, then they signed it, with the Father God, human being with intrinsic rights. I am writing in response to your correspondence dated March 29th, 2012, concerning my notice of amendment. I take this opportunity to cure sending my initial claim of right dated November 14, 2012, and my demand of appropriation sent to Monsieur Raymond Bachand, Minister des Finances. I claim the right to act as a teller on behalf of the Bank of Canada, or that the Bank of Canada has to provide for me a teller for the purpose of dealing with remittance slips, that when the document writings for remittance bearing the number, and she states her number, of her birth certificate, come into the Finance Minister's office, they will see that the Bank of Canada, through one of their representatives, me, have accepted it. I claim the right to access the Canadian Consolidated Revenue Fund to pay for my remittance slips. This said right is accorded to me through the document bearing, and she states her number again, and then she signs it. In the correspondence that this individual sends back, they claim the right to be a teller of the Bank of Canada. They claim the right to use 96, that 96 is your fixed thingamabob. They claim to be under the authority of God. They claim that they are with the Father God. And then in the correspondence they say, if there's a problem in what I'm claiming, contact me and let me know where I'm going wrong. Dear Madam, we are responding to your correspondence dated April 16th, 2012, concerning the claim of appropriation. We wish to inform you that we were asked by the department to respond to your initial request. Therefore, given the fact that your request has already been officially answered for and on behalf of the department, we consider this matter closed, and you will not be receiving any additional answers or responses. So, they write, we've examined your claim, we have responded, we're not going to respond again, and your claim doesn't entitle you on the obtaining shares based upon what you sent us. The Financial Administration Act, Article 26. It starts up saying, subject to the Constitution Act 1867 and 1982. Subject to this. No payment can be made out of the Consolidated Revenue Fund without an authority of Parliament. So the Receiver General's correct. No payment can be made out of the CRF without the authority of Parliament. However, this is subject to the Constitution Act of 1982. If there is an operation of law or several operations of law that allows a payment to be made out of the Consolidated Revenue Fund, then it's allowed to be done. The Receiver General is under obligation to make the reconciliation and allow that payment, allow that discharge to go through. So, it takes an authority of Parliament to allow a payment to go through, but this is subject to the Constitution Act of 1982. And what is the Constitution Act of 1982? The Constitution Act of 1982 is natural law, foundational law. It is where the obligations of the international instruments, the international covenants, find their expression, such as our right to enjoy a living and not pursue a living. So based upon this, we are back engineering what needs to be done.